Good morning, Your Honor.
Good morning, deputies. Can you all hear me?
Good morning, everyone.
Yes. Good morning, good morning. Happy holiday.
Your Honor, I'm
Yeah.
sorry, I forgot to ask you yesterday before we got started. Did you want me to follow along with this script, or did you just want to talk to the person that needed an interpreter directly like you did yesterday?
We'll talk to the person directly like we did yesterday.
All right, sounds good.
All right, thank you. All right. All right, good morning, folks. It is approximately 11:01 a.m. this morning. It is Christmas Eve, December 24th of 2023. My name is Judge Marcus Thorpe. I'm one of the Associate Magistrate Court judges here in Clayton County, and we are now streaming live on YouTube. Ladies and gentlemen, if you're having trouble hearing me this morning, please let me know either right now or as we go along with each of you individually so that I can make sure that you hear the important things that we'll be going over this morning. As I mentioned, this is your first appearance, and so I'm here to advise you of what you've been charged with and if there are any special conditions as it relates to bond on your particular case. So let me be clear, I am not here to try your case, to take a plea, or have any legal discussions in particular with you about the specific facts of your case. The purpose of this first appearance is to inform you of the charges against you, advise you of certain rights, set bond on those offenses for which the court is authorized to set bond, to schedule a preliminary hearing, and then also to determine whether or not you need the assistance of an attorney. As we do this, ladies and gentlemen, I need you all to keep in mind that you do have rights. You have the right to remain silent. I say that one first, most importantly, because I want to be clear that when I call each of you up individually, please do not talk to me about the specifics of your case or any defense that you believe you may have. This is streaming live. You have several people around you, both deputies as well as other inmates, as well as those of us who are here online with you. And so you make each of us witnesses against you if you decide to discuss your case. Now, in addition to the right to remain silent, you have the presumption of innocence. You have the right to an indictment by a grand jury for felonies or by accusation for misdemeanors. You have the right to a speedy and public trial by jury. You have the right to compel the attendance of witnesses to testify on your behalf. You have the right to see, hear, and question witnesses who are called to testify against you. You have the right to testify on your own behalf or offer evidence in your own defense. And you have the right to an attorney to represent you. And if you can't afford one, we'll discuss that this morning as I may be able to appoint one for you. Now, if there are any of you who are not citizens, let me advise you that some of these charges may adversely affect your immigration status. And so if that is the case for any of you who are not citizens, my advice to you would be to please contact an attorney, specifically an immigration attorney, to discuss those effects. Now, ladies and gentlemen, in addition to telling you what you've been charged with, I'm also going to tell you if you have a bond and how much your bond is and how you would go about posting bond. There are three ways in which you could make bond. The first would be to pay that bond in cash. The second would be the use of a commercial bonding company, or the third would be through what is called a property bond. Now, if you post a cash bond, someone, or either yourself, can deliver the full amount of the bond in cash together with any fees that the sheriff's office charges, who will then hold that amount until your case is closed, at which time your cash will be returned to you or to the other person who posted it on your behalf. Now, if you do not have the full bond amount in cash, you could also use what is called, as I said, a commercial bonding company. Now, typically, those companies will take anywhere from 12 to 15% of the bond for their fee, and that fee will not be returned to you. Now, lastly, you may also have someone post a property bond, so long as there is a certain amount of equity in the property. And so the example I like to use to give you all an example of each is if you're charged with family violence here this morning, so battery family violence. If I tell you your bond is $6,000, you have three ways to make that bond. You can pay $6,000 in cash. You can use a bonding company where you'd be responsible for 12 to 15%, which would mean roughly $750. Or the final way is a property bond, which would mean where you would have a friend or family member come up to the sheriff's office. They would have to bring the deed to the property they own. Now, the caveat to that is they have to have 3 times your bond in that house. So if your bond is $6,000, they'll need at least $18,000 worth of equity in the property. They would bring the deed down to the sheriff. The sheriff will hold on to that deed until such time as your case is closed. Now, folks, some of you all will have conditions on your bond that you are not to violate laws, as well as not to have contact or go to certain places. What I mean by that is, I may tell you this morning, you may have a no contact provision on your bond. What this means is you are to stay away and to have no contact with the alleged victim in your case. You may not call, text, email, write, or send a letter to or contact through any social media platform. You can't even do something nice for them, such as to send them flowers or to sing them a song, as ladies and gentlemen, that would be a violation of your bond. Now, if I order you not to return to a particular location, that means you cannot go back to that location for any reason. And so if the no return location is a shared residence, meaning a place that you lived before this incident happened, you are not to go back, and the only time you can go back would be when you are accompanied by a sheriff's deputy to collect some of your personal belongings that are not in dispute, meaning they belong to you. And you must do so within 10 days of your release. So again, the example we talk about, if you were arrested for family violence, and the incident is alleged to have happened at your home that you share with someone else, you are not allowed to go back. I will tell you that this morning, unless a deputy goes with you, and you have to do that within 10 days of your release. Your failure to listen to me as a result of these no contacts that I'll put in place, or to not return to a particular location, will result in your bond revocation. Now, lastly, ladies and gentlemen, that leads me to the final thing, or two final things that I want to discuss. There will be some of you all that will not be entitled to bond. And what that means is either because you are currently on probation, or the law does not allow me to consider bond because of the charges that you are facing. If that is the case, I will tell you here this morning and give you a new court date for a new bond hearing. Lastly, before we take the oath, I'm also going to ask each of you all who are charged with misdemeanors about what is called a preliminary hearing and whether you'd like to have one. The purpose of a preliminary hearing is to determine whether there is enough evidence, or what we call probable cause, to keep you detained on your charges. If you bond out, your hearing is automatically waived because you're out of jail and no longer detained. If you're charged with only misdemeanors when you come before the court, I'll ask you if you wish to have me set that hearing date or waive that hearing. If you say to me you want me to waive that hearing, instead of me setting a hearing, you remaining in custody, and that hearing happening in the next 30 to 40 days, what I'll do is I'll move your case, skip over the hearing, and send it right up to the prosecutor's office. It does tend to make your case move a little quicker, and then at that point, they will determine if there is enough evidence for your case to move forward. So I'll ask each of you that are charged with misdemeanors, again, whether you want me to waive that hearing or set that hearing date for you. So now at this time, ladies and gentlemen, if I could have each of you please raise your right hand. Do you swear or affirm that the information that you're about to give to this court, as well as any information you provided on your application for court-appointed counsel, is true and correct? If so, I need each of you all to say I do.
I do.
All right, you all may drop your hands. All right. Attorney Douglas, before we get started, I don't know if you saw the communication earlier, but at this point, Mr. Reed, as I understand, I don't think he's going to come up. And so I think what's going to have to be provided is some information just showing exactly that nothing's outstanding.
Okay.
I will say this though, Attorney Douglas, in reviewing some of the information you provided, I showed that the ticket was actually out of Clayton County. And so I guess what my question is, and it may just be not something we can clarify today, but if he was actually taken into custody for something out of Clayton, if that makes sense what I'm saying, because when I looked at it again.
Yeah,
okay.
So he had a failure to appear in Clayton on a speeding ticket.
Okay,
that he wasn't aware of, because again, the court notice was sent to his North Carolina address, where his mom lives. But he actually has and still does live in Atlanta. So he never received that notice. And that's why he had the failure to appear in the first place. And then he was in a car accident in Fulton a few days ago. And that car accident he was cited for that car accident. I think it was like following too closely or something like that. And because the failure to appear from Clayton popped up when the officer was citing him for that accident, they took him into custody in Fulton and then transferred him to Clayton.
Okay. So maybe I misunderstood you then. I thought you were saying yesterday the only outstanding thing was in Fulton. And so I guess, you know, that means he's got a warrant out of Clayton regardless for that failure to appear. I don't know that it will necessarily matter whether or not Fulton's case has been resolved. I mean, to the extent that you are able to show, hey, he has nothing outstanding, it may make a difference to whomever you speak to with the solicitor's office, because you know, if he's already been accused, because for him to have had an FTA, that means he came before somebody. You know, he was called in someone's courtroom. And
he had a first appearance in Fulton, and then when they released him on signature bond, then they brought him to Clayton.
Right. So then, you know, my thought process is a little differently than I think what we discussed before. I mean, I think to the extent that you're able to show, hey, he's got nothing outstanding, through whatever proper channels you acquire that from Fulton County, that assists you. But ultimately, I think you're going to circle back to the solicitor here, because, you know, if they've got the outstanding charge, they're going to be the ones that can discuss with you any removal of an FTA and or you know, reinstating the bond on that outstanding charge, because he's still got to dispose of that.
Right.
So it's not going to be a matter of him coming up to a first appearance. Yeah, he's just in custody here on that warrant.
Gotcha.
And so, you know, I mean, I think it's two levels at, you know, depending on how you choose to do it, but I think you've at least got the Solicitor General's office here and someone there. And then in addition to that, like I said, if you want to support whatever argument you want to make, it would be contacting Fulton to be able to show Clayton, hey, Clayton, look, the only thing he's got outstanding is this FTA from, you know, 2 years ago.
Got it.
I know, as I said before, I know that they don't open back up till Tuesday. What I can do, or what we can do, is just continue discussions, and you know, maybe you're able to get in touch with somebody from the solicitor's office between now and then. So if you let me just get through this, and then I'll be in touch with you then.
Definitely. Sounds good. Thank you, Judge.
Yes, sir. All right, so Ms. Tolles, can you hear me?
Yes, Your Honor. Good morning.
Good morning. All right, so I believe they have put, I believe it's Miss Loretta Lopez. Is that correct, Deputy? Deputy, can you hear me?
That is correct, Your Honor.
Okay. All right. So, Ms. Tolles, if you would, please go ahead and raise your right hand.
Yes, sir.
Do you swear or affirm that the information that this court will provide from you to you, that you will faithfully and truthfully interpret from English to Spanish to the individual before us?
I do, Your Honor.
All right. All right. So, if you would, Ms. Tolles, go ahead and introduce yourself to Ms. Lopez.
Buenos días, señora Loretta López. Soy su intérprete para hoy. Okay.
All right. So, good morning, Ms. Lopez. My name is Judge Marcus Thorpe.
Buenos días, señora López. Yo soy el juez Marcus Thorpe.
And I am going to go over the charges that the police have placed you into custody for.
Y voy a repasar con usted los cargos formulados en su contra, el motivo de que la policía la ha detenido.
Okay. Now, before I do that, I do want to make sure that you understand that I am just here to go over your charges and your bond, and we are not going to discuss your case and what happened.
Y antes de hacer eso, solamente quiero asegurar que usted entienda que estamos acá para que yo repase con usted los cargos imputados y la fianza. No es para que usted me explique los detalles de su caso o lo que pasó.
Está bien, gracias.
Okay, thank you.
Now, as a part of your bond, ma'am, I am going to give you some special conditions that are going to require you to stay away from the other individual involved in this, as well as the address, and I will need for you to follow them.
Como parte de la condición de su fianza, usted no puede acercarse a la otra persona involucrada en eso y tampoco puede acercarse a la dirección o el domicilio involucrado. Y necesita que usted se acate a esa regla.
Está bien.
Okay.
And please understand, if you fail to do so, it could subject you to additional charges.
Entiende, por favor, que si usted no cumple con eso, estaría susceptible a que le formularan cargos adicionales. Okay.
Now, when I give you this bond this morning, there are 3 ways that you will be able to make bond if you would like to be released while your case is still pending.
Si le doy una fianza esta mañana, hay 3 maneras que usted podría pagar la fianza si quisiera salir en libertad mientras su caso siga pendiente.
You can pay the full amount in cash.
Puede pagar la cantidad total en efectivo.
You can use a bonding company where you would only be responsible for 15% of that amount.
Podría hacer uso de una compañía de fianzas donde solamente usted estaría responsable de pagar el 15% de la cantidad total.
Or if you know someone who owns property, they can bring their property deed down to the sheriff for the sheriff to hold until your case is closed.
O si usted conoce a alguien que es propietario, esa persona puede venir a presentar la escritura de la propiedad a la oficina del alguacil, que la guardará como garantía de fianza por usted.
If you choose a bonding company, please keep in mind whatever 15% that you put up or someone puts up on your behalf will not be returned to you.
Si usted elige tramitar la fianza a través de una compañía de fianzas, entienda por favor que el 15% que usted paga o que un familiar pague por usted no se devuelve.
Also, please keep in mind, Ms. Lopez, that I'm going to advise you that you are to have no contact with the victim in this case. And so you cannot contact him in any way or have him bring down any money to help bond you out.
También tengo presente, señora, que le voy a prohibir contacto con la víctima en este caso. Entonces, eso significa que no puede tener ningún contacto en absoluto con esa persona. Tampoco puede él traer dinero consigo.
Now, I'm going to go over whether you would be given an attorney this morning.
Ahora voy a repasar los detalles para ver si usted va a recibir un abogado de oficio esta mañana.
And I'll be able to answer any questions about your process and any dates that you may have moving forward in this case.
Y luego puedo contestar sus preguntas sobre el proceso jurídico o las fechas pendientes más adelante.
Okay. And then lastly, you and I are going to talk about a preliminary hearing, which is a hearing with you, the judge, the lawyer, and the police officer who arrested you.
Y luego usted y yo vamos a hablar de lo que es la audiencia preliminar. Es una audiencia con usted, el juez, su abogado y el oficial que la detuvo.
And I'm going to ask you if you want me to give you that hearing, but you don't have to.
Y le voy a preguntar si usted quisiera que yo le programe la audiencia. Usted no tiene que tener la audiencia programada.
If you want that hearing, you only get it if you fail to bond out.
Si usted quiere que le dé la audiencia, solamente tendrá la audiencia si no sale en libertad bajo fianza.
Or you can tell me, Judge, I don't want my hearing. Please go ahead and move my case quickly and send it to the prosecutor.
Usted me puede decir, señor juez, no quiero tener la audiencia, por favor, haga el trámite para que mi caso se tramite más rápido ante la fiscalía.
Okay.
Señor.
All right.
Okay.
Okay. And you don't have to make that decision just now. I'll ask you at the end of our conversation.
Y no tiene que tomar la decisión ahora mismo. Le voy a volver a preguntar cuando terminamos la conversación.
So, Ms. Lopez, let me begin by telling you you are charged with 1 count of battery family violence.
Bueno, primero, señora Loreto López, voy a comenzar informándole que se le imputa un cargo de acometimiento violencia en el hogar.
Your bond amount is $3,500.
La fianza se le fija a $3,500.
You do have scratch that. You do have special conditions.
Su fianza conlleva unas condiciones especiales.
The first is to stay away from Edgar Rivera,
La primera es que no tenga ningún contacto con Edgar Rivera.
and the second is to stay away from the address of 262 Hummingbird Way.
Y la segunda condición es que no vaya o se aleje del 262 de la Hummingbird Way.
If that was where you were living before this allegedly occurred, then when you make your bond, please contact the sheriff to help you go get your things from that place until the case is closed.
Si ahí es donde usted vivía cuando el presunto suceso ocurrió, cuando salga en libertad bajo fianza, por favor haga una cita con la oficina del sheriff para que le acompañe a ir a recoger sus pertenencias de ese lugar.
All right, so do you have any questions about anything you and I have discussed so far?
¿Tiene usted alguna pregunta sobre lo que hemos hablado hasta ahora, señora?
Sí, sí, por favor.
Yes, please.
Okay, it's whenever you're ready.
Está
En
bien, adelante.
En este caso tengo dinero, ¿puedo pagar mi fianza? Bueno, tengo $1,000, ¿puedo pagar mi fianza?
In
Y
this
lo
case,
demás, terminarla de pagar fuera.
in this case, I do have money. Well, I have $1,000. May I pay my bond, or can I pay that and then pay the rest once I'm out?
Unfortunately, you cannot do it that way. If you are in the circumstances where you do not have the total 3,500, you can use a bonding company.
Lamentablemente no lo puedo hacer de esa manera. Si usted tiene la circunstancia de no cumplir con los 3,500 en total, entonces puede tramitar su fianza a través de una compañía de fianzas.
Okay. Now, let me ask you this, Ms. Lopez, are you working?
Ahora, le pregunto una cosa, señora López, ¿está trabajando?
Sí, estoy trabajando, por eso me urge salir.
Yes, I am working, which is why I really need to get out.
How much do you earn per month?
¿Cuánto está ganando al mes?
Como $1,000, 1,500.
Around $1,000, 1,500.
Okay. So, Ms. Lopez, I am going to go ahead and I'm going to give you an attorney free of charge who will help you on your case.
Entonces, señora López, le voy a dar un abogado sin costo alguno para usted para ayudarle en su caso.
Por favor, muchas gracias.
Yes, please. Thank you so much.
Now, if you remember, we talked about a preliminary hearing.
Ahora, si usted se acuerda, hablamos de la audiencia preliminar.
Now, because you were charged with a misdemeanor, again, I can waive that hearing for you and send it to the prosecutor, or I can set a court date for you. Which would you like for me to do?
Ahora, como a usted se le imputa un delito menor, usted podría renunciar a la audiencia y así yo puedo enviar su caso a la fiscalía, o usted puede tener la audiencia programada. ¿Cuál prefiere usted, señora?
Tener la audiencia programada.
I would like to have the hearing.
All right. So if you don't make bond, Ms. Lopez, your next court date will be February 6th of 2024.
Entonces, señora, si usted no sale en libertad bajo fianza, la próxima audiencia será el 6 de febrero de 2024.
¿Cuándo? Sí, bueno, en este caso, ¿cuándo podría salir?
Okay, so in this case, when could I get out?
That will be up to you, ma'am, and if you are able to make the bond either in cash or using a bonding company.
Eso depende de usted, señora. Si usted podría pagar la fianza en efectivo o pagando a través de una compañía de fianzas.
Ok, pero no sé si podría ser nada más dejar 2,000 y comprometerme a pagar el resto después. Es que sinceramente no tengo a nadie más aquí y no tengo quien me preste ni nada, ni tengo de ese que dice usted de la fianza, no tengo.
The thing is, I just don't know if I could pay the $1,000 and then be under obligation to pay the rest once I got out. The truth is, I don't have anyone here or anyone to loan me money. So I don't have the bond that you're referring
So,
to.
Ms. Lopez, unfortunately, that would mean you would have to remain in custody until such time as either your case is closed or your bond is lowered.
Entonces, señora López, eso significa que usted tendría que seguir detenida hasta que el caso se cierra o hasta que, I'm sorry, Your Honor, until your case is closed or
your bond is lowered.
o hasta que se reduzca su fianza.
¿Eso cuánto tiempo duraría?
How long would that take, Your Honor?
I can't tell you that, ma'am.
No se lo podría decir, señora.
All right, Ms. Lopez. Well, that's all I have for you this morning, ma'am. Thank you.
Bueno, señora López, es todo para esta mañana. Gracias. Okay.
All right. Thank you, Ms. Toth.
Thank you, Your Honor. Have a great day.
You too. All right, deputies. I should have, I believe it's Ms. Brielle Dunlap.
Yes, Your Honor. We done up.
Alright, y'all can put them in this order right here.
Yes, they're in order.
I'm putting looking for you.
Hello, are you Ms. Dunlap?
Yes, sir.
Hi, Ms. Dunlap, my name is Judge Thorpe, and I'm here to talk to you about what you've been charged with. Ms. Dunlap, you were initially charged with 1 count of theft by shoplifting and 1 count of contributing to the delinquency of a minor. The contributing to the delinquency, I have dismissed that charge, ma'am. There were some things missing in the warrant against you. Now, let me tell you, it doesn't mean that that charge won't come back, but as of right now, that charge is dismissed. Do you understand that?
I do.
Now, you do still have an outstanding charge of theft by shoplifting, and your bond amount on that is $1,500. You do have a special condition also, and that's to stay away from that Walmart 2940 Anvil Block Road here in Clayton County. Do you understand that?
I do.
So I have gone ahead based on the information you provided and appointed you an attorney this morning to help you on your case free of charge. So the last question I have for you is, when I discuss preliminary hearings, you have a right to one if you want it, or I can waive it and send you on up to the prosecutor and move your case a little faster. Which would you like me to do?
Would that be if I'm out on bond or if I stay here?
If you stay here. If you get out on bond, then you're going to automatically waive that hearing.
My mother is here with me. Can she, can I discuss this with her?
You cannot, unfortunately. So why don't I do this? Let me, to protect you, let me, again, if you make your bond, it's going to be waived anyway, but I'm going to set the hearing for you. And then again, as I said, if you make bond, it doesn't end up happening anyhow. So your next court date as of right now, ma'am, will be February 6th at 8:30 a.m. And that's going to be via Zoom, okay?
Okay.
All right, ma'am. That's all I have for you, ma'am. Good luck to you.
You got your bond now?
It's 1,500 is your bond.
You're good.
All right, I believe next I've got Miss Lola Frazier.
Got it out of order.
Who did you have next? Okay, are you Miss Frazier?
Ms. Edwards?
I'm sorry. Oh, you had Miss O. Okay, so Deputy Miss Edwards did make it.
Did make it.
Okay, 'cause I don't think I had a.
See, we had just something back. We just something them up, Your Honor. We was late on those. So Miss Edwards and Miss McNeely, we both sent their CA forms to you, maybe roughly 10-15 minutes ago.
Okay, because I did see them, but I wasn't sure if those were the same as earlier. Let's see. And so who do I have in front of me right now, though? Who is this?
This is Miss Favors, Your Honor.
Okay, so we'll do Miss Favors, and then we'll jump back to Miss Edwards. All right, so are you Miss Lola Favors?
Yes, I am.
Miss Favors, you are charged in this particular warrant. You had 2 charges. You were charged, 1 with battery, family violence, and then 2, the second charge being criminal trespass, family violence. Now, as it relates to the battery, ma'am, I have dismissed that charge. As of right now, there are some allegations or some information I was lacking. And so what I did do is I've dismissed that charge currently. Now, I want to be clear, ma'am, that does not mean that this charge won't come back at a later date against you. It just means as of today, the charge is dismissed. Do you understand that, ma'am?
Yes, sir.
Now, as it relates to the criminal trespass, I need you to understand that your bond amount is $5,000 on that. Now, you do also have special conditions on your case, ma'am, and that's to stay away from the alleged victim, Miss Carlia Anderson, and then also to stay away from the address of 6900 Creekmore Lane. And so, ma'am, if that was a place that you were living prior to this alleged incident, you will have to, if you make your bond, use the sheriff's office to get any things that you own out of that property. Do you understand?
Yes, sir.
Now, looking at the information, Ms. Favors, that you provided, how much are you earning per month working right now?
I really don't know.
Okay.
I just know I make $12.25 an hour.
Okay. So I am going to go ahead and appoint you a lawyer this morning free of charge for you. Now, if you heard me earlier, I was talking about a preliminary hearing. You can either have the hearing or waive the hearing. What would you like to do, ma'am?
I have it.
Okay, so if you don't make your bond, ma'am, your next court date is gonna be February 6th of 2024. That's gonna be at 8:30 a.m. and that's gonna be via Zoom. Do you understand that?
Yes, sir.
All right, if you don't have any questions for me, ma'am, that's all I have for you. Good luck to you. And are you Miss Edwards?
Yes.
So Miss Edwards, give me one moment here, Miss Edwards. Let me see if I can find your stuff here. Okay, I got it right here. All right, so Miss Edwards, you were charged with one count of theft by taking, ma'am. And your bond amount for that one charge is going to be $2,000, ma'am. Do you understand that?
Yes.
Now, as far as being able to help you with an attorney here this morning, I understand you are currently not working. Is that correct?
Yes.
So I am going to appoint you a court-appointed lawyer this morning as well. And then lastly, you have the right to a preliminary hearing that I mentioned earlier, or you can waive that right to that preliminary hearing, and then I'll send your case on up to the prosecutor, moving it along a little quicker. Which would you like to do, ma'am? Would you like to have that hearing or waive that hearing?
I want to have it.
All right, ma'am. So what's going to happen then is I'm going to set that hearing date. And for you, ma'am, that's going to be February 6th of 2024. And that's going to be at 8:30 a.m. via Zoom, okay? So again, it's going to be February 6th, 2024. And that's going to be at 8:30 a.m. via Zoom, okay?
Okay.
Do you have any questions about anything, ma'am?
No.
All right, ma'am. Well, that's all I have for you. Good luck to you.
Yes. We have Ms. Hawk, Your Honor.
All right, give me one moment, Deputy. Let me just give her stuff here. Make sure we keep everybody together. All right, and are you Ms. Hawk?
Yes, sir.
Ms. Hawk, you are charged with one count of giving a false name. Your bond amount is $1,500, ma'am.
Okay.
Looking at the information that you provided this morning, you said you're earning about $300 per month. Is that correct?
Yes, sir.
Now, as
like little side jobs.
okay, so as far as a preliminary hearing, I am going to ask you now, do you want to have that hearing or waive that hearing, ma'am?
I'd like to have it.
All right, so should you not make your bond, your next court date is going to be February 6th of 2024. It's going to be at 8:30 a.m. and that's going to be via Zoom. Now, based on what you provided about your work status, I am going to go ahead and appoint you a lawyer this morning who will be there to assist you on your case, okay?
Okay.
All right, ma'am.
Again?
It's $1,500.
Okay.
All right, ma'am. Good luck to you.
Thank you.
All right, Deputy, next up, is it Miss Hunter?
Yes, Your Honor.
All right.
Good morning.
Good morning. Are you Miss Hunter?
Yes, sir.
Ms. Hunter, I am holding here your warrant, and it says that you are been charged with one count of driving with an invalid tag, one count of suspended license, one count of no insurance, fleeing or attempting to elude, wrong side of the road, open container, stop sign violation, improper turn, obstruction, and reckless driving. As to the driving with an invalid tag, your bond is $500, the license $1,500, no insurance $1,000, fleeing $10,000. And then wrong side of the road, open container, stop sign, and improper turn are $500 apiece. The obstruction is $2,000 and reckless is $2,000. Your total bond, ma'am, is $19,000. Now, the information I have here, so you're making about $1,500 to $2,000 a month. Is that correct?
Kinda, sorta. It depends if they call me to work.
What kind of work do you do?
I work at Honey Baking now. And then I
Okay.
also do tattoos.
Okay, so it's not consistent.
No.
All right. So based on that, ma'am, I will go ahead and appoint you a court-appointed lawyer this morning. Now, as I've told everyone, you have a right to a preliminary hearing, or I can waive that hearing. What would you like to do this morning, ma'am?
I'll take a hearing.
All right. So that court date for you, if you don't make your bond, is going to be February 6th at 8:30 a.m. via Zoom. Again, that's gonna be February 6th, 8:30 AM via Zoom in 2024. Do you understand that?
Okay.
All right, ma'am, unless you have any questions for me, that's all I have for you, ma'am.
So you said that 19,000.
Yes, ma'am, 19,000.
So if I pay a bond, it'll be like $1,900, $2,000.
If you go through a bonding company, you're looking at about 12 to 15%. So not quite 1,900, it'll be closer to 2,500 you'd have to have.
25.
Yes, ma'am.
All right.
Okay.
Okay.
All right. Anything else I can answer for you, ma'am?
No, that's all.
All right. Thank you. Good luck to you.
Thank you.
Who do you have up next, Deputy?
Ms. Leon.
All right. All right. Are you Miss Deanjana Lee?
Deanjanae, yes, sir.
Deanjana, excuse me. Miss Lee, you're charged with one count of theft by conversion. Your bond amount is $5,000. Looking at the information you provided to us this morning, are you working right now, ma'am?
Not currently.
Okay, so I am going to go ahead and appoint you a court-appointed lawyer this morning. As to your preliminary hearing that I talked about earlier, would you like to have that hearing or waive that hearing?
I have it.
All right, so if you fail to make your bond, ma'am, your next court date is going to be February 6th of 2024, and that's going to be at 8:30 AM via Zoom. Do you understand that?
Okay.
Do you have any questions about anything?
That's it. You said 5,000, right?
Yes, ma'am, 5,000.
Okay.
All right, any questions I can answer for you?
No, sir, that's it.
All right, ma'am, well, good luck to you.
You're gonna have Miss McNeely. Taylor.
All right. Yeah, all right, Deputy, give me 1 second here. Let me just get this in order. Give me one moment, Miss McNeely. I'm almost done with what I'm doing. I just want to make sure we keep everything together.
You're fine.
What was gonna sign here and I just clicked. Okay, so that makes, this is where we are?
Yeah, that's one.
And it's McNeely, is that correct?
Yes.
Miss McNeely, did you fill out some paperwork this morning? Oh, hers came in late.
Yes.
Yours came in late. Okay, give me 1 second. Let me get that up. Miss McNeely, you were charged with one count of theft by shoplifting, and your bond amount is going to be $1,500, okay?
Okay.
Now, you are going to have special conditions, ma'am, and that's going to be to stay away from the incident location where this allegedly happened. And that's going to be that Walmart there off of Anvil Block Road at 2940 Anvil Block Road. Do you understand that, ma'am?
Yes.
Do you have any questions about anything we've talked about so far?
No.
I see here, ma'am, that you're working. It says that you're earning about $1,500 a month. Is that correct?
Yes.
So what I'm going to do, ma'am, I am going to appoint you a court-appointed lawyer this morning to help you with your case. So you will have that assistance, okay? And then lastly, I need to ask you, you have a right, as I mentioned earlier, to a preliminary hearing, or you can waive that right. What would you like me to do on your case, ma'am? Would you like to have it or waive it?
Have it.
All right, ma'am. So your next court date is going to be February 6th, 2024 at 8:30 AM via Zoom, okay?
Wait, what was it? I'm sorry, can you say it again?
February 6th of 2024 at 8:30 AM, and that's going to be via Zoom.
Okay.
Okay.
Yeah.
All right, ma'am. If you don't have any questions for me, that's all I have, ma'am. Good luck. All right. Next up should be, is it Miss Tucker?
No, she's no longer here. She booked out.
Oh, that's right. She bonded out. Okay. Who do you have next, Deputy?
Vassar. Vassar.
Okay. Let's see. Did Dominique Nicholson and also bond out, or is that a male? Maybe I'm showing that one.
It's a male.
Okay, got it. Okay, give me 1 second, Ms. Vassar. All right, so are you Ms. Vassar? Ms. Danielle Vassar?
That is correct. Good morning, Your Honor. Happy
Good morning.
holiday.
Good morning, ma'am. Same to you. So, Ms. Vassar, you are charged with 1 count of theft by shoplifting and 1 count of contributing to the delinquency of a minor. Ma'am, as to the delinquency charge, I have dismissed that charge here this morning as there was some insufficient information for me to make the decision on that. Now, it doesn't mean that that charge won't come back later. Just means right now, as of today, it's dismissed. Do you understand that?
Understood.
So your bond on your remaining charge is $1,500 on the theft. And you do have a special condition, ma'am, and that's to stay away from that Walmart there at Anvil Block Road, 2940 Anvil Block Road. Do you understand that?
Understood, sir.
Now, lastly, I need to ask you about a preliminary hearing, whether you would like to have that hearing or waive that hearing, ma'am. What would you like to do?
I would like to have that hearing, sir.
Okay, ma'am. So if you fail to make your bond, then what's going to happen is they will give you that hearing, and it's going to be February 6th of 2024, and it's going to be at 8:30 a.m. via Zoom, okay?
Yes, sir.
Now, lastly, so you're earning about $2,500 a month, is that correct?
That is correct.
Do you still have that job, ma'am?
I do, sir. Yes.
And would you still have it if you're released on bond?
Yes, I will.
Okay, so as of right now, ma'am, I am not able to appoint you a lawyer. And so if you would like a lawyer to assist you on your case, you will have to hire one on your own. Do you understand that?
I do. May I ask a question, sir?
Yes, ma'am.
Is that because of the amount?
I can't answer that, ma'am, but at this point, I'm just unfortunately not gonna be able to appoint you one.
Not a problem, sir. Understood.
Okay. Anything else I can answer for you, ma'am?
That is all at this time. Once again, thank you and happy holiday.
Yes, ma'am. Same to you. All right, and I believe that should be all of our females. Is that correct?
Yes, sir.
So we should have, beginning with the males, Mr. Alexander should be first.
I have one question, well, two
Yes,
before we start. All right, so
Mhm.
Eric Reed, I think he has an attorney. Do you still want to see him?
No, he was here earlier. We discussed that. They're just gonna have to bring him back at a later day.
Understood. And can we see Mr. Bell first, Mario, since he's kind of disruptive? Yeah, all
We sure can. You can bring him up now.
right, go ahead and bring Bell up. Thank you, Your Honor.
Yes, ma'am. Are you Mr. Bell?
Yes, sir.
Mr. Bell, let me get your paperwork here. You are charged with 1 count of theft by shoplifting, 1 count of battery, and 1 count of obstruction of the officer. As to the theft by shoplifting, sir, your bond amount is $10,000. As to the battery is $7,500. And as to the obstruction, your bond amount is $5,000 for a total bond of $22,500. Now, sir, you do have special conditions on your bond, which means you are to stay away from the alleged victim, Miss Broderica Henderson, and also from the address of 6489 Terra Boulevard. Okay?
All right.
Were you residing there, sir? Were you living there? Were you living there before this happened?
Where?
At this address, this Terra Boulevard address.
No, this Sierra Boulevard address. That address is supposed to be a Dollar General.
Oh, it's a Dollar General. Okay, I see that now. So you're just not to return there, okay? Now, let me ask you this, Mr. Bell. I see you are not working, so I am going to go ahead and appoint you a lawyer to help you on your case, okay? Do you understand me, Mr. Bell?
Oh, yeah. Yes, sir.
Okay. And then lastly, sir, I need to go ahead and give you your next court date. Because you are charged with a felony theft by shoplifting, you will get a preliminary hearing, and your preliminary hearing, sir, is going to be February 7th of 2024, and that's going to be at 8:30 a.m., and that's going to be via Zoom. Do you understand that, sir?
Yeah. Yes, sir.
All right. Do you have any questions about anything, Mr. Bell?
No, sir.
All right. Good luck to you, sir.
Now you're going back to.
All right, so next up should be Mr. Alexander.
Let me get Mr. Alexander. You gonna be the intake?
Yeah, intake.
Good morning, what do you want, sir? What's your last name? Yes, sir.
All right, so good morning, Mr. Alexander.
How you doing?
I'm doing well, sir. Mr. Alexander, you are charged with 1 count of no license, 1 count of driving with a suspended license, and 1 count of driving with an invalid tag. Your bond amount for the first 2 charges, driving with with license not on your person, driving with a looks like your license that you did have has been suspended, and then driving with an invalid tag. The license charge is $500. The ID charge, the invalid identification registration sticker is $500, and the suspended license is $1,500 for a total of $2,000 in bond. Do you understand that?
Yes, yes, sir.
And how much are you making per month, sir?
3 coins. Actually, I just got back down here. I'm just about to start back work.
Hey, what kind of work are you doing?
I was doing audio visual.
Okay. So you're currently not working at the very moment?
I mean, yeah, I mean, just until the Christmas holidays over with. I just got back down from Texas.
Were you working before then?
Yeah, in Texas I was.
And about how much were you making per month?
Per month, probably like 3,000.
Okay.
Like 750 a week, something like that.
Okay, so based on that, sir, I'm not going to be able to appoint you a court-appointed lawyer, so you'll have to get your own if you want one on this case, okay?
All right.
Lastly, sir, you're charged with misdemeanors. As I talked about earlier, you have a right to a preliminary hearing, or I can waive your hearing and send your case on up to the prosecutor and move it along quicker. Which would you like me to do?
Waive my hearing, so I can make this bond.
Yep, you can make this bond. All right, sir.
Can I ask you one question? I have no oath. I'm asking you this because when I got locked up, I did weekend jail for Riverdale, actually here in Clayton County in 2014. But the dude said he took me to jail because I had a probation hold.
Okay, you're talking about things you probably don't want me to hear on a recording. Okay.
I need you to sign that.
Yeah, so you're waiving your hearing, you're charged with misdemeanor, sir, and you'll need to get your own attorney if you'd like one for your case, okay?
Yes, sir.
All right, thank you, sir. All right, next up, I've got Mr. Beecham. Are you Mr. Beecham? Are you Mr. Beecham?
Yes, sir.
Mr. Beecham, you're charged with 1 count of violation of the Georgia Controlled Substances Act, 1 count of possession of a firearm by a convicted felon, and 1 count of theft by receiving. Your bond as to the VGCA is $3,500. As to the firearm is $8,000, and as to the theft, it is another $8,000 for a $19,500 bond. Do you understand that?
You said 19,500?
Yes, sir.
Yes, sir.
And I understand here from what I'm looking at that you are working. About how much are you earning per month?
It depends, Your Honor, because like I have set schedules for the week. Like it's not a set schedule. Like they make it as they go. So
what kind of work do you do?
I'm a cook.
Okay, so roughly, give me an estimate how much you make per month.
Probably not even $2,000 a month.
Okay, so based on that, sir, I am going to go ahead and appoint you a court-appointed lawyer this morning to help you on your case, okay?
Yes, sir.
Now, because you are charged with felony, sir, I'm going to have to give you your next court date if you don't make bond. Your preliminary hearing court date, is February 7th, and that's going to be of 2024 at 8:30 a.m., and that's going to be via Zoom. Again, that's going to be February 7th, 2024, 8:30 a.m., and that's going to be via Zoom, okay?
Yes, sir.
All right, good luck to you, sir.
All right, thank you.
Thank you. Next up, this is Arthur Burgee, B-U-R-G-E-E.
Edward Brown, sir.
Oh, excuse me. How did I?
Must be wrong.
Hold on, it's okay.
Can't.
What was the name, Deputy?
Edward, my name is Edward Brown. I don't know what the other guy was that supposed to be in front of me.
Beecham is right. His name is Edward Bernard Brown.
Give me 1 second. I did not. Okay. Give me 1 second, Deputy, because I don't think I got any paperwork on him. Oh, here it is. Okay, I see his deputy. So deputy, I've got him last because he's a fugitive from justice. I wondered if we could do him just before Mr. Hastings. That's why his was out of order.
Okay.
Sorry about that.
Yes,
Yeah, just hold on, sir. We'll be right back to you. Give me a couple minutes.
you just go ahead and go back and fix. Yeah, yeah, so he'll go back.
Wait, so I'm a fugitive.
Yes, sir.
What you mean?
I'll talk to you about it, Mr. Brown.
Right.
All right, so it should be Mr. Burgee next, Burgee. Are you Mr. Burgee?
Tony Brown.
Are you
What's the last name, deputy?
Brown? This is Tony Jerome Brown. Oh, I see. Yeah, you're, okay, so you're gonna go last too.
Yeah, I got the same for him too.
Yeah,
Yep.
all right, so you'll go last. All right, so Mr. Arthur Burgess.
Okay,
Okay, sir, come on. Excuse us for that.
no problem. Are you Mr. Burgee?
Yes, sir.
Mr. Burgee, you are charged with 1 count of battery. Your bond amount, sir, is $3,500. You do have special conditions, sir. I'm gonna ask that you stay away from the alleged victim, Miss Jamie Holland, and also from the address of 5930 Highway 85. Do you understand that, sir?
Yes, sir.
Now, because you're not working, I am gonna go ahead and I'm gonna appoint you a lawyer free of charge that's gonna help you on your case, okay?
Yes, sir.
So let me ask you one last thing. I talked about earlier preliminary hearings. That's where I can have you, the judge, the lawyer, and the police present to talk about your case, and you'll get a hearing about whether they've got enough evidence. Or I can waive your hearing, skip over it, and send your case on up to the prosecutor to move it a little quicker. Which would you like me to do? Have your hearing or waive it?
The quickest possible.
That's up to the judge. I can't get to know.
I like to have the quickest possible, get out.
Okay, unfortunately, I can't, the date's already set in stone, sir. So for your case on a misdemeanor charge, I can tell you that that court date is going to be February 6th at 8:30 a.m. and that's gonna be via Zoom. That's the fastest we can have it, okay?
Yes, sir.
Any other questions I can answer for you?
No, not I can think of.
All right, sir. Well, that's all I have for you, sir. Good luck to you.
And what I do now, I can't, I'm released?
No, sir, you'll be in custody unless you can make that bond that you and I talked about
Okay.
to your court date, okay?
Seven.
All right, anything else I can answer for you? All right. Next up, it should be Martez Bird.
Mr. Martez Bird.
Good morning, Mr. Bird.
In my name.
Mr. Bird,
Yes.
you're charged with 1 count of criminal trespass, 1 count of public indecency. Your bond amount on the trespass is $1,500, on the indecency exposure charge of $2,000, for a total amount of bond of $3,500. Do you understand that?
Yes, sir.
You can write it down if you.
Now, you, sir, you will have a special condition. You are not to return to the Atlanta airport unless you are there for travel or work. Do you understand that?
Oh, yeah.
Now, I have appointed you a lawyer this morning. Lastly, I need to ask you, your preliminary hearing, sir, would you like to have that hearing or waive that hearing?
What's when?
So your hearing would be February 6th of next year, 2024, or I can waive it and try to get you up to the prosecutor much faster.
So I get to the prosecutor, then yeah, give me to the prosecutor because I'm guilty.
Okay, sir, I can't, let's not say that on the recording. But what I'll do, I'll show that you waived it and you want me to send it on up to the prosecutor's office. Is that correct?
Uh-huh. So
right, sir.
what day is when?
No, so you.
I can't tell you when your next court date's gonna be. Your lawyer will give that to you, but Madam Deputy there to your left is gonna have a document that she needs you to sign,
It'll
okay?
be before February though.
I can't tell you that, sir.
It'll be before a preliminary hearing.
I can't tell you that, sir. All I can tell you is by doing that, it does move it a little quicker.
So it does move it quicker, so it will be before February.
I'm not gonna make that promise, sir. We're coming out of the holidays, but we're coming out of the holidays, so I can't tell you how
But you said it's
quickly.
quicker though, my friend. You said it's quicker than the first.
Deputy, if you could have him sign the document, because he's not listening to me.
It's right here in front of him, Your Honor.
I'm gonna go straight to the thing. I'm gonna
Okay,
wait.
sign the document and waive. This is your
All right.
waive form, so go ahead.
Thank you,
and
sir.
waive it.
Having where probable
no.
cause and defendant shall be bound over for trial to the state.
You're gonna, the top part is what you're looking at, so.
Defendants waive for preliminary hearing. I have been informed of my right preliminary report to examine the issue of probable cause for the necessary for. I fully understand the purpose of a preliminary hearing, and I do desire to have such a hearing. By waiving this hearing, I have no way indicating my guilt. By waiving this hearing, I have no way indicating my guilt or innocence of how I desire to plead. If any have waived probable cause.
Wait, that's where you're gonna sign right
Yeah,
there.
they got probable cause.
Okay, so remember, make sure you don't want to say those things this is being recorded.
I ain't know y'all keeping misdemeanors that fast. That's down. Y'all keep misdemeanors for that long. Y'all can't be fooled.
Yes, sir. All right. Good luck to you, sir.
All right, go ahead and go back.
All right, next up should be Mr. Craig Corley, Corley.
You can write down your court date and times and all that.
Are you Mr. Corley?
Yes, Your Honor.
So, Mr. Corley, you are charged with one count of concealing the ID of a motor vehicle. I have reviewed your charges this morning. Let me advise you, you're going to be released this morning. That does not mean that your case is dismissed. It just simply means that you're going to be out for the time being. Do you understand that?
Yes, Your Honor.
All right. And so I also, looking at the information you've provided here this morning, sir, I am going to appoint you a court-appointed lawyer if you need one for your case. Do you understand that?
Yes, Your Honor.
Okay. Now, because you are going to be released, you are waiving your right to the preliminary hearing. And so Madam Deputy is going to have a document there for you to sign. And once you sign that, you should be released roughly in about the next 24 hours. Okay.
Thank you, Your Honor.
Thank you, sir.
Thank you. All right, go ahead and step aside for the next.
Thank you very much.
Yes, sir, you have a-
This should be Mr. Daly.
Mr. Daly? Right, that's him.
Are you Mr. Daly?
Yes, sir.
All right, so Mr. Daly, my name is Judge Thorpe here, and I'm reviewing your information here with you. You're charged with one count of driving with a suspended license and one count of a stop sign violation. The suspended license carries a bond amount of $1,500. The stop sign violation, a bond amount of $500 for a total bond of $2,000. Do you understand that? Okay. Now, looking at the information that you provided here, sir, I am going to go ahead and appoint you a court-appointed lawyer this morning, okay? And then lastly, we talked earlier about what a preliminary hearing is and your right to it when you are charged with a misdemeanor. Would you like to have that hearing or waive that hearing? Can you hear me, Mr. Daly? Say that again.
If I waive the hearing, what happened?
So again, remember what I talked about the difference. A preliminary hearing is a hearing where you, the judge, the lawyer, as well as a police officer are there to determine if there's enough evidence against you to move forward on your case. Or you can tell me, Judge, I don't want to have that hearing. I can waive that hearing, and then I'll send your case directly to the prosecutor, which moves the case a little quicker. Okay, so your choices again are, yes, Judge, give me that hearing. If I don't make my bond, I'll have it. Or no, Judge, I don't want that hearing. Go ahead and send my case to the prosecutor.
Oh, so if I make the bond, then
You don't get it anyhow. Yes, sir. What would you say that again?
if I bond, does this affect my bond in any way?
No, sir, it does not. Only thing that happens if you make your bond, the hearing is automatically waived regardless.
Oh, yeah, I guess I waive the bond.
I hear you said you wanted to waive it. Is that correct? All right, so I'm going to show that you waived your bond here this morning, sir. And Madam Deputy is going to have a document there for you to sign.
I thought we could hear it now.
Sign right here.
Here.
Thank you so much.
All right, next up should be Mr. Dion Davis. Are you Mr. Davis?
Yes, sir. Good morning.
Good morning, sir. Mr. Davis, you are charged with 1 count of theft by shoplifting. And in review of the information here, the bond amount that's been set, sir, is $1,500. Now, you do have a special condition, sir, and that's to stay away from the address of 2940 Anvil Block Road. That's the Walmart there in Clayton County. Do you understand that?
Yes, sir.
And I understand you make about $2,000 per month. Is that correct?
Yes, sir.
Will you still have that job upon your release?
Yes.
So right now, I am going to show then that you do not qualify for a court-appointed attorney. And so you will have to hire your own attorney if you so choose to have one with you, okay? Okay?
So do I got a bond?
Yes, your bond amount is $1,500 for that theft. Now, lastly, because you're charged with a misdemeanor, sir, you have a right to a preliminary hearing. You can have that hearing or you can waive that hearing if you so choose. Which would you like to do? I'm sorry? Okay, but my question to you is about the hearing, the preliminary hearing. Would you like to have that hearing or waive it?
I guess for the court date.
Say that one more time.
For the court date.
Okay, so the court date would be February 6th of 2024. But remember, if you bond out, you lose the right to it regardless.
So that's fine. That's fine.
When you say that's fine, what do you mean? Would you like me to set the court date for you? Or...
Yeah, set the court date for me.
All right, so I will go ahead, sir, and set that court date for you. It's going to be February 6th of 2024, and that's going to be at 8:30 a.m., and that's going to be via Zoom. So remember, again, sir, if you make the bond, you've automatically waived your right to it. But if you don't make the bond, that'll be your next court date via Zoom, okay? All right, sir, good luck to you. Next up should be Mr. Edwin.
Mr. Edwin?
All right, are you Mr. Edwin?
Yes.
All right, so Mr. Edwin, you are charged with 1 count of battery, family violence, and 1 count of terroristic threat. The battery, family violence carries with it a bond amount of $3,500. The terroristic threat of $8,000 for a total of $11,500. Do you understand that, sir?
Yeah, but the lady that I don't know nothing to that lady, he just take me and beat me up. That's all he do.
Okay, so remember what I said earlier. I can't talk to you about the facts, so don't tell me that information. You'll be able to tell your lawyer that, okay?
He beat me up. That's all he do.
I understand. Now, sir, let me say this. In addition to your bond amount, you do have special conditions. That means that lady that you just spoke about, don't talk to her. You'd have no contact with her.
Yeah.
Okay? And that address where this happened, at 1880 Thornton Way, don't go back to that address, okay?
But I have all my clothes there, everything there.
And so remember what I said earlier. If that's where you live and you make your bond, get with the sheriff's office and they will escort you there with you, okay?
But she's not going to take my things or get rid of it. I have important things.
I can't comment on that, but what I can tell you is if you make your bond, the only time you should go back to that address is with her, with the police with you, okay? Now, lastly, sir, I've given you a court-appointed attorney to help you on your case, so it'll be free of charge. My last question for you is, or excuse me, the last thing I want to tell you is, because you are charged with a felony, you don't make your bond, your next court date, sir, is going to be February 7th, and that's going to be of 2024, and that's going to be at 8:30 a.m. via Zoom. Do you understand that, sir?
Yeah. But my son want to bail me out, my son.
Okay. Yeah. If you make your bond, sir, then that court date, you won't have it, okay? All right? You got me, sir?
Yeah, but they don't take my statement when that happened. She break my neck or my...
Remember, hold on. Remember, we don't want to talk about that.
Yeah,
wait and talk to your lawyer about that, okay? Okay? Your lawyer can help you on that, but that's all I've got for you, sir. Good luck to you.
Yeah. You want the number for my son?
No, sir, we don't do all that. When you go back to your pod, they'll help you with that, okay? All right.
All right, next up should be Mr. Fleming.
Mr. Fleming.
All right, are you Mr. Clarence Fleming?
Yes, sir.
All right, so Mr. Fleming, you are charged with 1 count of violation of Georgia Controlled Substances Act, 1 count of possession of marijuana over an ounce, and 1 count, under an ounce, and 1 count of drug possession or possession of drug-related object. Your bond on the felony drugs is $5,000, on the marijuana $1,000, and on the drug object $500. So your total bond, sir, is $6,500. Okay?
6,000.
Yes, $500.
Yes, sir.
Now, I am going to appoint you a court-appointed lawyer here this morning based on some information you provided. And because you are charged with the felony, if you don't make bond, your next court date is going to be February 7th at 8:30 a.m. and that's going to be via Zoom. Do you understand that?
Yes, sir. February 7th, 2024.
Yes, sir. 8:30 a.m. and that's going to be via
8:30
Zoom.
a.m. via Zoom. Yes, sir.
All right. Thank you, sir.
Thank you very much.
Yes, sir. All right. Next up should be Mr. William Fowler.
So 12% of the what, maybe 6.
All right. Are you Mr. Fowler? All right. So, Mr. Fowler, you are charged here with 1 count of entering an automobile, 1 count of possession of a firearm by a convicted felon, 1 count of possession of tools during the commission of a crime, and 1 count of possession of a firearm during the commission of a crime. As to the entering auto, your bond amount is $10,000. As to the possession of a firearm by a convicted felon, your bond amount is $10,000. As to possession of tools during the commission of a crime, your bond amount is $10,000. Now, as to the final charge, possession of a firearm during the commission of a crime, no, it's separate charges. Entering auto, possession of a firearm by a convicted felon, possession of tools during the commission of a crime, and then possession of a firearm during the commission of a crime.
That's the same thing.
So it's a little it's different, sir. So listen to what I'm saying. Entering auto is 10,000, firearm by convicted felon is 10,000, tools during the commission of a crime is 10,000, possession of a firearm during the commission of a crime. I have dismissed that charge.
Thank you.
Okay. So your bond amount right now is going to be $30,000. Yes, sir. That's correct.
How much would that be to get out? If I go to a bonding
If you wanted to use a bonding company, sir, you're looking at roughly about $4,500.
Okay.
Are you working right now, sir?
No, ma'am, my mom's down from Tennessee though.
Okay. And so I am going to appoint you a court-appointed lawyer that's going to help you on your case, okay?
Thank you.
Now, if you don't make bond, your next court date is going to be February 7th of 2024, and that's going to be 8:30 a.m., and that's going to be via Zoom. Do you understand that?
Yes, ma'am.
Sir. The judge.
I'm a man. Oh, yes, sir.
You're fine. You're fine.
I can't
All
see
right, sir. That's all I got for you, sir. Good luck to you.
Yes, sir.
Next up should be, I've got Mr. George next. Are you Mr. George?
Yes, sir.
All right, so Mr. George, you are charged with 1 count of aggravated battery and 1 count of criminal damage in the second degree. Do you understand that?
Yes.
Now, the aggravated battery charge, I'm going to dismiss, sir. There's some information that is required for me to review that was lacking in this document, and so I've dismissed that charge. And so the only remaining charge is the criminal damage in the second degree, and your bond amount on that is $10,000. Do you understand that?
Yes, sir.
Now, I see that you are not working here, so I am going to go ahead and appoint you a court-appointed lawyer, so that's going to be free of charge. And your next court date, sir, should you not make your bond, is going to be February 7th of 2024, and that's going to be 8:30 a.m. via Zoom. Do you understand that?
Yes.
All right, so $10,000 bond, February 7th, 2024, 8:30 a.m. All right, sir. Thank you. Next up should be Jordy Guerrera. Are you Mr. Guerrera?
Yes, sir.
All right, Mr. Guerrera, you are charged with 1 count of reckless conduct and
Yeah. Judge, if you can hear us, we can't hear you, you froze. Where's the clip?
Hey, he'll be back up. Just wait. Give him like 2 minutes. He'll come back up.
You know, y'all took us on.
Huh?
You know, you took us off in the midst of him.
Huh?
You took us off in the midst of the judge talking to this man right here.
No. The judge froze. He did that. He having
Okay.
technical difficulties. It's normal down here. It's normal. But he'll be back up in like 2 minutes.
Okay.
Your Wi-Fi probably went down.
All right.
All right.
Good.
Just give him a
I
minute.
forgot my com, I forgot my E.
It's all good, don't worry about it.
You can go back mute. You can mute.
I can mute you? Okay.
Gonna be a little bit.
Can you hear me?
Yes, sir.
Okay, I'm back. Sorry about that. I'm not sure what
That's
happened.
okay.
I
Forgive my
think we were
misspelling and my.
okay.
All right, so let's start again.
All right, I think we were at Mr. Guerrera, Guerra.
Yes, sir.
All right, so Mr. Guerrera, I was advising you're charged with discharging a firearm in the bond amount of $5,000. The reckless conduct, you were initially charged on that as well, sir. I have dismissed that charge as of today. What I need you to understand, however, it doesn't mean that charge won't come back, but as of today, it has been dismissed, okay?
Okay.
Now, I've looked over the information you provided. How much are you making per month right now?
Not that much, probably like 1,500, 2,000.
Okay, do you have any children?
No.
All right, so 1,500 or 2,000. I'll go ahead and appoint you a court-appointed lawyer this morning. Let me ask you this. I spoke about a preliminary hearing. That's the hearing where you, the judge, the police, and your attorney are present to determine if there's enough evidence to go forward against you, or I skip that hearing and move your case along faster and send it to the prosecutor. Which would you prefer me to do? Set that hearing date for you or to move it to the prosecutor?
So if I bond out, I lose that first preliminary hearing, correct?
Yes, that's correct. You lose it regardless.
Okay, so yeah, I'll go ahead and bond out.
Okay, so would you like me to then waive that hearing?
Yes.
Okay, so I'm gonna show that you have requested I waive that hearing. So Madam Deputy is gonna have a document there, sir, for you to sign if you would. And then that's all I have for you this morning, sir. Good luck to you.
All right, thank you so much.
Thank you.
Yeah, back to you.
But you gotta stand right here and read it. It's just saying that you chose to waive your,
Okay, yeah. Thank you.
yes, sir. Good luck to you.
All right, next up should be Mr. Jeremiah Hardy. Are you Mr. Hardy?
Yes, sir.
Mr. Hardy, you're charged with one count of theft by receipt of stolen property. Your bond amount is $5,000. I'm showing here, you are working or you are not working?
No, sir.
No, you're not working?
No, sir.
Okay. So I am gonna appoint you a court-appointed lawyer here this morning, sir, to assist you on your case. Now, because you are charged with a felony, I'm gonna go ahead and tell you your next court date, if you don't make bond, is gonna be February 7th at 8:30 a.m. And that's gonna be via Zoom, okay? Again, that's February 7th, 8:30 a.m. And that's gonna be via Zoom. Do you understand that?
Yes, sir. I got a question though.
Yes, sir.
If I get on today, will it be waived or I still gotta wait?
Say that one more time.
If I have somebody to pay the bond today, right?
Uh-huh.
Will it be waived or I still have to wait?
Your hearing will be waived. You'll just be out on bond until they contact you via mail for your next court date.
Okay.
Okay?
Sign it.
Yes, sir.
All right, yes, sir.
Oh. What I do?
Here, he did something.
Yeah, when I was typing it.
This one?
Sir,
So, yeah.
Sir.
Your Honor,
Yes, sir.
Your Honor.
Yes, sir, I can hear you.
Am I done?
Yes, sir, you're done.
Okay, thank you.
Yes, you're done. Okay. Deputy, can you hear me?
I can hear you now, Judge.
Okay. Next up should be Mr. Nicholson. Are you Mr. Nicholson?
Yeah.
Mr. Nicholson, how much are you making per month, sir?
What?
Okay.
Too much?
What kind of work you do, sir?
I do Ghost Recon.
I'm sorry, say that one more time.
Ghost Recon?
Okay, sir. So I'm gonna go ahead and appoint you a lawyer this morning to help you on your case, okay? Now, I need to advise you, sir, you are charged with one count of aggravated assault. Because I'm showing here that you are currently on probation out of Clayton County, I can't give you any bonds. So you're gonna be on a no bond status this morning. Do you understand that?
What it is?
That means you're gonna be sitting in custody with no bond until your next court date.
All right.
Now, you're gonna have two court dates I'm gonna give you right now. So I need you to pay attention. Your next court date is gonna be February 7th of 2024, and that's gonna be at 8:30 a.m. via Zoom. That's your preliminary hearing. February 7th, 2024, 8:30 a.m. via Zoom for prelim, okay?
February 7th?
Yep, February 7th. And then your second court date that I'm gonna tell you about is gonna be your bond hearing day. They're gonna look at your bond again and make a decision whether to change your bond or not. And that's gonna be February 9th, 2024, 8:30 a.m. Okay, 8:30, February 7th for prelim, February 9th for your bond hearing, okay? All right, sir, that's all I have for you this morning. Good luck to you. Next up should be Mr. Chiwuka Ukakpu.
Yes, sir.
All right, sir. So you are charged with one count of theft by shoplifting, one count of public drunk, and one count of criminal trespass. The theft by shoplifting carries a bond of $1,500, the public drunk $1,000, and the trespass $1,500 for a total bond of $4,000. Do you understand that, sir?
I didn't get, you said 1,500 and two.
And 1,000?
1,000.
Yes, sir. And so your total bond is 4,500. You are going to have special conditions, sir, and that's to stay away from the address of 7411 South Lake Parkway. Do you understand that?
Yes, Your Honor. Is there any way we can speak about a reduced bond?
No, sir, we
because I'm
cannot.
out of county. Okay.
No, sir, I cannot. Lastly, sir, I have to ask you about a preliminary hearing. Would you like me to have set your hearing date for you, or would you like to waive that hearing?
I'm not sure what that means.
Okay, so earlier I talked about preliminary hearings. When you're charged with a misdemeanor, you have a right to have it or waive it. A preliminary hearing is where you, the police officer, the judge, and your attorney will be present to review the evidence and determine if there's enough evidence for your case to move forward. Or I can skip that and send it on right up to the prosecutor, who will make that same determination, but your case moves a little quicker. So which would you like me to do? Waive that hearing and send it to the prosecutor, or set that hearing date for you?
Yeah, can you just waive the hearing?
All right, so I'm going to show here, sir, that you have asked that I waive your hearing date. And so Madam Deputy is going to have a document there for you to sign. And once you sign that, that's all I have, sir.
All right, thank you, Your Honor.
Thank you, sir. All right, next up should be Mr. Sally. All right, are you Mr. Sally?
Morning, how you doing?
Good morning, sir. Mr. Sally, you're charged with one count of violation of the Georgia Controlled Substances Act, one count of possession of a firearm during the commission of a crime, and one count of possession of a firearm by a convicted felon. Now, because you are charged with a felony, sir, and I'm showing here that you are on probation, it appears to be out of Baltimore, Maryland. I am not permitted to give you bond. That's what I'm showing here, sir. If that's, hold on, you don't want to comment on that. Don't comment. If that's incorrect, sir, I am going to appoint you a court-appointed lawyer. So you're making about $4,000 a month? I'm talking to you, Mr. Scott. Oh, excuse me, Mr. Sally. How much are you making per month?
Per month? I don't have an accurate amount. I do off the books jobs.
Okay, give me 1 second, Mr. Sally. Give me 1 second here. Mr. Sally, did you fill out some paperwork earlier today asking you how much you're making per month?
Yeah, I put NA.
Okay. I just want to make sure yours might have been one of the ones that came in a little later. Give me 1 second, Mr. Sally.
Yes, sir.
Yep, I got you right here. So, Mr. Sally, I show you're not working. Is that correct?
Yes, sir.
Okay. What I'm going to do, sir, is I am going to go ahead and appoint you a court-appointed lawyer this morning. And so that lawyer will be free of charge, so you don't have to pay for that, okay?
Okay.
But now, as I told you before, I know you wanted to comment, but remember I said earlier, this is being recorded. So I don't want you to say something that may or may not be true or put yourself, in a bad position. So for today, I am not going to be able to give you bond, but you'll be given a lawyer, and that lawyer will be able to review that with you. And so if it turns out that what I'm showing is incorrect, they'll be able to help you on that, okay?
Okay.
Do you have any questions? Now listen, I'm gonna ask you this. Well, remember, don't say certain things you don't want to say. Do you have any questions about what we just talked about procedurally wise?
Procedurally, no bail due to the fact of probation in Baltimore, correct?
Correct. So no bail, no bond. You are correct due to the fact that I'm showing you are currently on probation. Yes, sir, that's correct.
The state of Baltimore. Okay, well, the city.
That's what it's showing on what you have showing here. But again, if that's incorrect, we will have somebody that will be able to assist you on that at a later date when you'll get appointed your attorney. Your attorney will reach out and they'll be able to go through that stuff. And like I said, if it turns out that that's incorrect, they'll be able to change it. But while I got you there, let me give you your court dates. Now, because you're going to be in custody, at least for the time being, you're going to have 2 court dates. The first is going to be February 7th of 2024, and that's going to be at 8:30 a.m. via Zoom. That's going to be for your preliminary hearing date. And the next court date after that will be February 9th of 2024, and that's going to be at 8:30 a.m., and that's also going to be via Zoom. All right.
February
Any
7th, February 9th.
Yes, sir. February 7th, preliminary hearing. February 9th is your bond hearing. And those will be the dates that they'll be able to review the information I'm looking at. And they may have more information that shows that that's incorrect, okay?
All right, and question, is there like a time span on an amount of time before your legal aid basically comes sees you?
Not that I'm aware of, sir, but they're usually pretty quick about that. So, I mean, I would say expect someone to be in contact with you in the next 2 weeks at most.
So with that, all right, last question. With that being asked, is there a way that the bail date could be sped up?
There is not.
So far back?
No, sir. Unfortunately, there is not. Those are preset dates.
All right, thank you.
Thank you, sir. All right, next up should be Mr. Scott, Darren Lee Scott. Are you Mr. Scott? Mr. Scott, you're charged with 1 count of DUI less safe. Your bond amount is $5,000, sir. Because of the information that you've provided here, Mr. Scott, I am not going to be able to appoint you a lawyer this morning. So you will have to hire your own lawyer. Do you understand that, sir?
Yes.
Now, also looking at this information here, I need to ask you about a preliminary hearing. Would you like to have your hearing, sir, or waive your hearing?
Is it preliminary hearing right now or is
No, sir. It would be in 30 days. So your preliminary hearing is where you have the judge, lawyer, you, and your attorney present to review the evidence and determine if there's enough evidence to move forward in a case against you. If they determine there is not enough evidence, your case could be dismissed. You only get that, however, is if you remain in custody. If you make your bond, you waive your right to that hearing altogether.
I'd like to get a bond.
I'm sorry?
I'd like to bond up today.
Okay. And you will be able to do that, but regardless of whether you bond out or not, what would you like me to do about your hearing, your preliminary hearing? If you don't make your bond, do you want to have that hearing with the judge and your lawyer, or do you want to waive that hearing? And I'll send your case right on up to the prosecutor.
I'll waive it.
All right, sir. So I'm going to show that you have.
I'm not gonna let you go until you get a full understanding of what he was saying since it froze again. Who's Charlotte that come?
That's he's going.
Just anything. So if you wanna go ahead, you go ahead and sign this. This is for waiver.
First and last name.
No, I'm gonna put your personal information. Last name is Scott, right? All right. Darren. Lee, middle name?
Darren Lee Scott.
Go. Go. Bye. He said, yeah, you just gonna stand here till you come back so that way we can make sure you got the proper information that you need.
So the contents and make sure it's not to do no legal advice.
I don't think we are, but he just said it.
All right. All right, we're back. Can you hear me, sir?
Yes, I can hear you.
All right, sorry about that. And your name, you're Mr. Scott, correct?
Yes, Your Honor.
So, Mr. Scott, you're charged with 1 count of DUI less safe. I was saying the $5,000 bond. Based on what the amount of money you make, sir, I'm not going to be able to give you an attorney. You're going to have to hire one on your own. But I was asking you about your preliminary hearing, sir, and what you'd like me to do about that. And what I was explaining to you is a preliminary hearing, if you don't make your bond, is where you, the judge, your lawyer, and an attorney that you have now hired, will get together and they're going to review the evidence against you and determine if there's enough evidence that the case can go forward against you. Okay. Now, the flip side of that is you can tell me, Judge, I don't want to have that hearing. You can skip that hearing and send my case on up to the prosecutor, where I will await for them to look at it and determine if there's enough evidence. Really, the big difference is between the two. If you tell me, Judge, you want to skip that hearing, doing so means your case does move a little faster on to the prosecutor. Okay?
Okay.
So what would you like me to do, sir? Would you like to hold that hearing or waive that hearing?
I'd like to waive that hearing.
All right, sir. So I am going to show that you asked that I waive that hearing and to go ahead and send it up to the prosecutor. So Madam Deputy there is going to have a document that you'll need to sign, okay?
Okay.
And then once you sign that, sir, that's all we've got for you.
So is that it?
Yeah, you understand your bond, you got your bond and all that?
Did you have some questions, Mr. Scott?
So the 5,000, I would need 10 or 15% of that to bond up.
You can either do it all in cash at 5,000, or you can do 12 to 15% of that with a bonding company, which would mean you'd roughly need about 750 in cash.
Okay.
All right, sir. Good luck to you.
Have a good day, y'all.
You too. Next up should be Mr. Sellers. Are you Mr. Sellers?
Yes, sir. Good morning, y'all.
Good morning, sir. So you're charged, Mr. Sellers, with one count of possession of marijuana over an ounce, one count of possession of a firearm during the commission of a crime, one count of possession by a convicted felon, and one count of improper lane change. The marijuana charge carries a bond of $9,000. The weapons charge $9,000. The lane change $500 for a total bond of $18,500. Now, you did have a second charge, a convicted felon charge. Let me say that what I have before me, sir, does not allow me to determine that. Don't you respond. But what I have is not allow me to make that decision if you are a convicted felon or not. So I have currently dismissed that charge. Now, that doesn't mean that it won't come back at a later date. It just means as of today, that charge is not pending against you. Do you understand that?
Which charge are you talking about, sir?
Possession of a firearm by a convicted felon.
Okay, perfect. I got you.
Now, as to preliminary hearing date, sir, because you were charged with a felony, I need you to understand your next court date, if you don't make your bond, is going to be February 7th of 2024, and that's going to be at 8:30 a.m. via Zoom. Do you understand that?
Yes, sir.
All right, sir. That's all I have for you. I have appointed you a lawyer this morning, so you will get a lawyer free of charge to help you on your case, okay?
Yes, sir.
All right. Good luck to you, sir.
Thank you.
Next up, I have Mr. Joseph Tucker.
Good
Are you
afternoon,
Mr.
Your
Tucker?
Honor.
Good
Yes,
morning, sir. Mr. Tucker here, I've got charges here pending showing you are charged with one count of simple assault, one count of tampering with evidence. The tampering with evidence charge, sir, is a bond amount of $2,000. The simple assault, I have dismissed that charge, sir, in that there are elements missing that the law enforcement officer was supposed to put in the warrant, okay?
Yes.
So I'm telling you that to tell you right now that charge is being dismissed. Doesn't mean it won't come back, but as of right now, it's dismissed against you, okay?
Yes, sir.
So I have appointed you a lawyer, sir, who's going to help you on your case free of charge. The last question I have for you, Mr. Tucker, is this. You have a right to the preliminary hearing I talked about earlier, or I can skip that hearing and move your case a little faster and send it on up to the prosecutor directly for their review. Which one would you like me to do? Set that hearing date for you or send it to the prosecutor?
Well, I'm a little confused because this is my first time getting into this
Sir.
document.
Yes, sir. No problem. You've been arrested, sir, and alleged to have committed a crime. We don't know if you've done it or not, and there are certain things that are in place to protect you, okay? Now, I gave you a bond, which is a number that you can use to try to get out and to secure your right to come back to court. You can make that bond in one of three ways. You can make that bond by paying it all in cash, $2,000. You can make that bond by using a bonding company, which would mean you'd have to come up with about $300 to $400. Or you can have somebody who owns a piece of property like a house, and they can bring their deed to their house up here to help you bond out. Now, if you don't make your bond, I can do two things. One, I can set a hearing for you with you, your attorney, the judge, and the police, and you're gonna look over your case, right? It's not your trial. Or if you tell me, Judge, I don't wanna have to wait for that hearing date, I'd rather you move my case a little quicker and send it on up to the prosecutor and waive my hearing, okay? So which would you like to do? Waive your hearing or set that hearing date for you? Here's what I'm gonna do, sir, because I know it's confusing for you. I don't want to not protect you, so I'm gonna set that hearing date for you of February 6th at 8:30 a.m. and it's gonna be via Zoom. And what I'll do is, what'll happen is, if you make your bond, Mr. Tucker, you waive that hearing regardless. But if you don't make your bond, it'll be again February 6th, 8:30 a.m. and that's gonna be via Zoom, where they will go over your charges with you again, okay?
Yes, sir.
And I have appointed you a lawyer to help you out on your case.
So can my mom pay my bill? I'm at my bond.
Yes, sir, she sure can.
Okay, thanks.
Yes, sir, thank you. All right, next up should be Mr. Walker.
Thank you.
Are you Mr. Walker?
Yes, sir, Your Honor.
So, Mr. Walker, you are charged with 1 count of open container, 1 count of obstruction, and 1 count of possession of less than 1 ounce of marijuana. As it relates to the open container, your bond amount is $500, to the obstruction, $2,000, and the marijuana, $1,000, for a total bond of $3,500. Do you understand that, sir?
Yes, Your Honor.
Now, you are charged with misdemeanors here, sir, so you have a right to a preliminary hearing, or you can waive that hearing. Would you like to have that hearing or waive it?
You just said it.
Set it? Okay, so your next court date, sir, will be February 6th of 2024 at 8:30 a.m. And that's gonna be via Zoom. And so remember again, as I told the gentleman before you, if you make your bond, that hearing will be waived. Otherwise, that'll be your next court date, okay?
Yes, sir.
And based on the information you provided to me, sir, you do not qualify for a lawyer free of charge this morning. And so if you do desire a lawyer to help you on your case, you will have to hire your own, okay?
All right, that's cool.
All right, sir, I believe that's all I have for you. Good luck to you, sir.
Thank you. Merry Christmas.
Same to you. All right, next I am showing, are you Mr. Whipple?
Willis.
Excuse me, Willis.
Where's Mr. Willis?
Do we have a Ja'Cory Whipple?
Do we have a Willis?
Yes, we do have one.
Or did he bond out?
Is that guy? We're checking, Judge.
Sure, no problem. In the meantime, are you Mr. Donald Willis?
Yes, sir, I am.
Okay, so Mr. Willis, I am showing here that you were charged with 1 count of tinted window violation, 1 count of possession of marijuana less than an ounce, 1 count of violation of Georgia Controlled Substances Act, 1 count of possession of a firearm during the commission of a crime, and 1 count of possession of a firearm by a convicted felon. As to the tinted window charge, your bond amount is $500, the marijuana $1,000, the VGCSA $3,500, and then lastly, as to the firearm by a convicted felon, $8,000. Now, as to the possession of a firearm during the commission of a crime, I have dismissed that charge because the allegations were incorrect. So your total bond, sir, is going to be $13,000. Okay?
What was it? The first one was 500.
500. Marijuana is 1,000. The violation of Georgia Controlled Substances Act is 3,500, and the convicted felon charge is 8,000. And for a total of 13,000.
13.
Yes, sir.
Okay.
Now, I need you to understand here also that because you are charged with felonies, your next court date is going to be February 7th of 2024, and that's going to be 8:30 a.m. via Zoom if you don't make your bond, okay?
Yes, sir.
And I have gone ahead and appointed you a court-appointed lawyer, so you will have a lawyer free of charge to also help you on your case, okay?
I appreciate it.
Yes, sir. Anything else I can do for you this morning, Mr. Willis?
No, sir. You have a good afternoon.
All right, you too, sir.
Thank you.
Mr. Whipple is now present, Judge.
All right. Are you Mr. Whipple?
Yes, sir.
So, Mr. Whipple, you are charged with 1 count of criminal trespass and 1 count of disorderly conduct. The Okay, so I've reviewed all of the information, sir, that was provided to me against you. I need to let you know that I am dismissing those charges this morning. Now, I need you to understand, sir, that does not mean they won't ever come back. They may come back later. But as of right now, sir, the charges against you are being dismissed, which means you should be released in the next 24 hours, okay?
Excellent.
All right. Do you have any questions for me, sir? Thank you.
Thanks.
All right, so that should leave us with the two gentlemen, Edward and Tony Brown, and then Mr. Hastings last.
Yes,
So if you
sir.
want to bring Edward and Tony up.
Can I get that one, Tony? Yes, you can. They're en route to you, Judge.
Okay.
Edward Brown.
All right, give me 1 second here.
Yes, sir.
All right, give me 1 second, sir. I'll be right with you. I want to make sure I've got all of everything in order for you here so we can take care of you. All right. And you are Mr. Edward Brown, is that correct?
Yeah, yes, sir.
Okay, so Mr. Edward Brown, okay, so we had a, okay. So Mr. Edward Brown, you're just charged with DUI, seatbelt violation, open container. So Mr. Brown, your DUI is a bond amount of $4,000, your seatbelt is a bond amount of $500, and the open container is a bond amount of $500 for a total bond of $5,000. Do you understand that, sir?
Yes, sir, I do. May I speak, sir?
Yes, sir, go ahead.
But I couldn't do the sobriety test. I can't pick up my leg. I got a walker. And I told him that. Now,
Okay, so hold on, Mr. Brown. I'm gonna stop you right here, and I don't mean it to be rude.
okay.
But let me explain something to you. As I said earlier, this here is for your preliminary hearing. So I'm just advising you of what you've been charged with. So I want you to be careful. That's why I cut you off, man, because I don't want you to say something that may hurt you down the line. Okay, so
Yes, sir.
what you're talking to me about, I would advise that that's something that you talk to your lawyer about. That's going to be your case. Okay.
Okay.
All right. So now let me ask you this, Mr. Brown. Are you working right now?
Yes, sir. I'm a Vietnam veteran. I work at the VA hospital on Clonmar Road.
Okay.
1670.
So let me tell you this, Mr. Brown, I am going to go ahead and appoint you a court-appointed lawyer this morning. But more importantly, let me also tell you this. Because you are a veteran, sir, there's going to be a special program that you're going to be a part of that we're going to contact you with over at the courthouse in a couple of days, okay?
Yes, sir.
And so you just be on the lookout for both your lawyer as well as somebody from that program contact you, okay?
Yes, sir.
All right. Any questions of me, sir?
Do you need my correct emails and phone numbers and stuff like that so you can?
The only other thing I need from you is this. Because you're going into that program, I'm going to
Yes,
ask
sir.
Madam Deputy. She's going to have a document to show you that's going to waive your preliminary hearing. But
Yes,
other than
sir.
that, sir, I don't need anything else from you.
That's it, sir.
Yes, sir. That's it.
Okay, I'm not too bright on this bond thing, so my daughter, she probably been coming to get my card to try to help get me out so I can get back to work.
Okay. Yeah,
Okay, so
she'll be permitted to do that.
okay, thank you, sir. I appreciate
Yes, sir.
it.
Thank you.
I stomach hurt and I gotta get some medicine
Yes,
quick.
sir.
Can they give me some medicine over there?
You can go to the, you can go to Maryland.
Yeah, I need some medication bad.
This a different, this one.
I'm hurt. I got pain medication.
All right, and then that should leave Tony Brown before Mr. Hayes.
Yeah, I signed the right one?
Yes, sir, you did.
Yeah. All right, thank you. I need something.
And are you Mr. Tony Brown?
Tony Brown, yes. Yes, sir.
You said yes, sir?
Yes, sir.
Okay. Well, Mr. Brown, you know, I had you come up last because your situations, I'm sure you know already, is a little different. We're holding you here not because of any allegations of any commission of a crime within the state of Georgia or within Clayton County. Specifically, I was provided a document here showing that they're alleged that you committed a crime of larceny in Charleston County, where the Charleston County Police Department, okay? So what I'm here to do is not for you to talk to me about what happened or to discuss anything like that. So I would ask you, please don't talk to me about your charges, okay? I'm just here for you to make one decision. So now here's where we are. Because you were picked up in Clayton, you have a couple or one choice really to make. And that's about whether or not Charleston County is going to come and pick you up and bring you back to Charleston County to deal with those charges, okay? So here's your choice. Choice one is you tell me, Judge, I don't believe that they are doing the proper things to go about bringing me back to Charleston County, okay? That means you want to fight your extradition, which means you want a hearing here in Clayton County. If you tell me you want that hearing will be in the next 30 days, okay? If for some reason it doesn't happen in 30 days, the law does give us an additional 30 to give you that hearing. So you could be in custody for 60 days at most. If you say, Judge, I don't want to contest my extradition, I don't want to contest the procedure, I want them to get me back to Charleston County as soon as possible to deal with these charges, you can waive your right to that hearing, okay? And if you do that, Charleston County has to come get you within 30 days. And if they fail to do so, you will be released, okay?
Yes.
So again, option one, I want to fight it procedurally, not the underlying charge, not the charge, but I want to fight the procedure. Or I want to waive it and tell them to come get me as soon as possible. Which would you like to do, sir?
Yes, I like to waive it and
All right.
So yes.
All right. So what's going to happen then is Madam Deputy is going to have documents to sign. You're going to have about 6 of them, the same thing over and over that you'll have to sign. Once you've done that, sir, that's all I've got for you. And then the Charleston County will be contacted.
Okay.
You're gonna sign up here at the top. Oh.
All right. And then Deputy, that should just leave us with Mr. Hastings. Mr. Hastings, can you hear me?
Yes, sir, I can. Good morning.
Good morning, sir. Or good afternoon, rather. So Mr. Hastings, I looked over the information that was provided here to us this morning. As you may be well aware, sir, you are charged with 1 count of discharging a firearm while under the influence of alcohol and 1 count of reckless conduct. Do you understand that, sir?
Yes, sir.
Okay, we did set a bond for you, sir. Your bond amount is $2,500 per charge for a total bond of $5,000. Do you understand that?
Yes, sir.
Mr. Hastings, are you working right now?
I just got a new job.
Okay. So based on that, sir, I am going to go ahead and appoint you a court-appointed lawyer here this afternoon that will help you on your case, okay?
Yes, sir.
Now, you are charged with a misdemeanor. So that means you do have a right to a preliminary hearing, but you don't have to have it. A preliminary hearing is where you, the judge, the lawyer that you have, as well as the police officer will be present, and they'll talk about the evidence against you and whether there's enough evidence to move forward against you, okay? Or you can tell me, Judge, I don't want that hearing. Go ahead and send my case directly to the prosecutor so that I can move this case along faster. Now, which would you like me to do? Would you like to have that hearing, or would you like to waive that hearing?
I would like to wait the hearing on it.
All right, so I'm going to show here that you are waiving that hearing. So at some point here shortly, someone from the sheriff's office is going to provide you a document for your signature, showing that you waived that hearing, okay?
Yes, Your Honor.
All right, sir, that's all I have for you, Mr. Hastings.
Thank you, Madam President.
All right, thank you. All right, Madam Deputy, I think that's all we have.